Proceed.
I am, Your Honor.
You may proceed, sir. Would you like to reserve some rebuttal time?
I would, Your Honor. I'd request to reserve 5 minutes for rebuttal.
All right, you got it.
Thank you, sir. May it please the court, this case is about a foreclosure matter, but specifically is regarding whether a plaintiff must in fact have an original note at the inception and at trial. In this case, the plaintiff did not have the original note either prior to trial, at inception, nor at trial. In fact, the so-called notice of filing original from pages 119 to 141 of the appendix makes it very clear that the so-called original is a redacted copy. And the
Mr. Ackley, let me jump in on this for a minute. Was this argument about the lack of an original note and mortgage, wasn't this made at the earlier appeal? I thought I saw a reference to it in your brief on the case that went up before our court previously.
Yes, but not this issue, which is not the issue before the court before, was whether or not having the original at trial. This is whether or not having the original note, period. Our position is that the court or the plaintiff had previously asked the court to take judicial notice of the filing of an original note. But if the court were to look at that so-called original note, that's not original either. It's a redacted copy. So there was never a note before the court, either at trial or at the inception of the case. The prior appeal was regarding at trial alone. But here the problem is that they used a note to verify this case in trial that is unrelated entirely to my clients, unrelated to the property, unrelated to the case entirely. And there was never, and that was the note that was entered into evidence.
I was under the impression that the opposing counsel conceded that point at the trial, that there was a mistake made in the note that was introduced, but that your client ultimately conceded that the original note and mortgage were in fact in the court file.
I don't believe we've ever conceded that they were in fact in the court file.
Well, there's a finding in the order on appeal that there was such a concession made.
Your Honor, we did not. The entire point of this appeal is that there was no original note at the inception. The so-called original that was so-called filed with the court is a copy. It's a photocopy.
I'm reading from the order. The order denying defendant Miles Christian Hart's motion to vacate final judgment and canceling the hearing on the motion. On page 206 of the order of the court below, the court notes Mr. Christian Hart's concession made during the 22nd February 2017 hearing before Judge Mercurio that the original note and mortgage are in the possession of the clerk of the court. Court asks the question, is the original note and mortgage as it relate to Mr. Hart in the court file? Ms. Michelle, who was representing Mr. Christian Hart, said, I believe it is, Your Honor. Ms. Calhoun said, yes, Your Honor. It was previously filed on June the 13th, 2012.
Yes, Your Honor, that was an error on the part of counsel, and that's the error we're trying to address here today. The fact is that when you look at the so-called original note that was filed, it's on pages 120 to 126 of the appendix. It's clear that that's not an original note. So there was never an original before the court, ever, under any circumstance. So the question before the court
today. So this is a new argument that you're making.
This is the argument we made in our brief, Your Honor.
Was that ever raised at any point before this brief? Before your brief in this case?
I believe that, no, Your Honor. Before, the issue before the court was whether or not there was an original at trial. So, and the plaintiff's counsel below, in the trial court below, in the motion for rehearing, actually asked the court to take judicial notice of the filing of the original. Well, that doesn't satisfy the court's need to actually have an original.
So are you you're trying to correct or go around what Ms. Michelle told the court, that the original note was in the file since 2012? You're saying that's incorrect?
That's clearly incorrect, Your Honor. Absolutely. Yes. And that's the problem, because this court, the trial court, never had an original note in this case, whether filed with the clerk, and even though the court was asked to take judicial notice of that filing, the simple fact is that it wasn't an original. And so how can a court now foreclose on a property or allow a foreclosure to move forward when the fundamental document that substantiates and forms the basis of any foreclosure is missing from the case entirely? The plaintiff has, its counsel has
Well,
argued.
but your predecessor counsel already conceded the point that the original note and mortgage were in the file since 2012.
But that was error, and that was evidently error. That was clearly evident as error.
Well, I'll let it go and let your opposing counsel address what you're arguing now. Go ahead,
Before
sir.
you move on, then explain to me for the future, if we follow your rule that somebody can go back at that point, how would the opposing side know if it's not raised in the lower court?
Well, it was raised. There was an erroneous answer to that, Your Honor.
Well, but it was, how would the opposing party and opposing counsel know once the record is complete if that's not the issue on appeal? You're bringing up something new and just saying it's an error.
They would know because they're the ones that supposedly entered the so-called original into the record, Your Honor. That's the plaintiff is the party that filed this notice of filing original note and mortgage and filed a copy instead of an original. The problem is with the foreclosure, you've got to have an original somewhere, and it doesn't appear here anywhere.
Your predecessor counsel said the original was in the court file since 2012, sir.
And that was error, Your Honor.
Well, that went up on appeal. Our court looked at it. There was an opportunity to address what was in front of the court at the foreclosure trial. Both sides argued it. It's in the briefing for both sides. Our court looked, there's no transcript from the trial.
There is no transcript from the trial.
Wells Fargo says that the original was in the court file, that there was just a misfiling of the note that was brought to the trial. We have no way of verifying that one way or the other since there's no transcript. It seems like the sum total of your argument is your predecessor lawyer was wrong.
Well, it's not the sum total, Your Honor. The fact that the lower court took.
I mean, I didn't read where anybody said that the note and mortgage that was filed in 2012 was not the original authentic note and mortgage. You're saying that today is the first time I've ever heard that.
Well, that's fundamental to our argument, Your Honor.
That was 9 years ago. Go ahead.
Well, under 90.953, it's fundamental that a negotiable instrument, you need to have the original at trial and certainly at the inception of the case. And here it's not present at any point. Under the Heller case, you could have the counsel stipulate to the authenticity of the original, so-called original, but that didn't happen here. And it went to trial and it went to foreclosure and it's been appealed and it's had a motion for rehearing and a motion to vacate, all of which have been denied, all in error, because the simple fact is the court's never had an original before it.
Okay.
That's my argument, Your Honor.
Anything else?
No, thank you.
All right. Ms. Rotman.
May it please the court, Emily Rotman with McGuire Woods on behalf of Applee Wells Fargo Bank. I think this court clearly understands the issues here, but to recap briefly, where we are in these proceedings is 11 years after the foreclosure was filed in 2010, trial took place in 2015. There's no transcript of exactly what happened at that trial, although there does appear to have been perhaps some clerical error with respect to which note was included on an exhibit log. Appellant and his counsel filed several post-trial motions at that point, including motions for new trial. All of that was taken up on appeal via multiple appeals to this court that were consolidated. Those issues were affirmed, and specifically in those appeals, there was significant discussion of whether the original note was at trial and whether that was required and whether there were any issues stemming from that. That was all discussed in detail. After the per curiam affirmance, there was a motion for rehearing that was denied, a motion for clarification was denied, and former counsel for appellant was actually cautioned to cease filing things that raised the same argument again and again. Went back down. There's now essentially a repackage of the same argument requesting that the court now vacate the judgment as void. The court took a look at it below and wrote a very detailed order explaining why that was inappropriate, including because this court had previously considered many of the same issues. And as the Your Honor recognized, and it's in Wells Fargo's appendix starting at page 142, appellant's counsel recognized that the original note was already in the court file. So that was all done, and now we're back here again. Wells Fargo's position is that this case, it's time for some finality here and some finality of this judgment. This court did previously consider a number of issues related to the filing of the original note, and it was per curiam affirmed. Counsel's argument does appear to be slightly shifting at this point. As I read the motion to vacate final judgment in the lower court case, it argued that the original note was not in evidence, raising the same evidence log issues raised in the prior appeal. I think today is a slightly new argument, but as this court has recognized, counsel did previously acknowledge that the original note was on file. There's nothing in the record to walk that back at this point, and there's nothing for this court to consider to do that. Turning briefly to whether this judgment is void in any way, plaintiff's argument simply fails, or appellant's argument simply fails. There's nothing to show that the lower court lacked jurisdiction in any way, or whether over subject matter or over appellants in any meaningful fashion. There's no question that appellants were served. They appeared at trial and defended. So at its core, this appears to be a lack of standing argument at best, which is an issue that was addressed in the prior appeal, and it's an issue that should be addressed on a direct appeal, not 6 years after the entry of judgment, asking this court to walk that back. I want to turn briefly to the issue of which note, of where the note was. There's no question, and counsel previously conceded that the original note and mortgage were on file with the court as of 2012. Correct copy of the notes attached to the complaint referencing the Hart's mortgage. Similarly, the judgment references the correct legal description for the mortgage. So I don't think it appears that there may have been a clerical error, as counsel that was present at the foreclosure trial acknowledged. They previously filed it, asked the court to take judicial notice, and they did some due diligence afterwards when they realized what may have happened with the evidence log, realized it was a note and mortgage from another case that went to trial that same day that their firm did not handle. Can't explain exactly how that happened, but that appears to be what happened. But the original note and mortgage were on file years before trial took place. Unless the court has any questions, for the reasons stated in our brief at oral argument, we would respectfully request that the judgment here be affirmed.
Thank you, counsel. Mr. Ackley, you have your rebuttal.
Yes, Your Honor. The argument that clerical error was responsible for the entry into evidence of the wrong note is simply not supported by evidence. The only evidence before the court is that the note that was used at trial was not the note that is related to this case and had no relationship to this case at all. Many of the same issues are, but not the same issues. If we want to walk that back, the simple fact is we're arguing that the underlying judgment is void because in a foreclosure action, you've got to have that negotiable instrument in order to make your case, and it's not here. There was a redacted copy entered into the record on June 12th of 2012. That's not an original. And the court couldn't take judicial notice of that, couldn't authenticate it by taking judicial notice. And counsel couldn't properly create a note where one doesn't exist. And then the fact that the wrong note was actually entered into evidence is in and of itself the point. There is no original
Mr.
note.
Ackley, wouldn't what you're asking us to adopt create clouds of title all over the place, or the potential for that? If an attorney could come back after the fact and say they were wrong, people would be examining court records all over the state to see if they could find some problem with an underlying document and say, well, the trial judge was wrong, my counsel was wrong, we're going to challenge that entire judgment.
I don't know, Your Honor, but I do know that what we're looking at here is a note that is completely unrelated to the case at hand being used to supposedly create a cause of action and provide for judgment against my client and allow the plaintiff to take the house in foreclosure when the only evidence in the case has nothing to do with my clients. and no relationship to my clients. That is not a usual case. I don't think that's going to appear very often. What we're talking about here is they didn't have a witness to testify or to bring in the original. They didn't file the original with the court. And then at trial, they used the wrong note. That's incredible. And it just shouldn't be allowed to go forward.
All right, Mr. Ackley, anything else?
No, Judge.
All right, thank you both. Appreciate the argument, and we'll move on to the next case.